How can you prove lack of mental capacity for a will contest? Imagine trying to change your estate plans, but someone claims you weren't in the right mind when you signed your will. How do they prove that? Well, proving lack of mental capacity in a will contest is all about showing that at the time you signed the will, you didn't understand what you were doing. The law assumes adults are capable of making a will unless someone proves otherwise. So, the person challenging the will has the tough job of providing clear evidence that you lacked the mental ability when you signed it. To do this, they need to show that you didn't understand that you were making a will or what a will does. They also have to prove you didn't know or remember what your property was worth or who your family members and loved ones were. If you had a mental disorder like dementia or were experiencing delusions that affected your judgment, that could be used as proof. What kind of evidence helps show this? Medical records are very important. If doctors or mental health professionals diagnosed you with dementia, Alzheimer's disease, or other cognitive issues around the time you sign the will, that can be strong proof. Witness testimony is also useful. Family members, friends, or caregivers who saw you confused, forgetful, or acting strangely can describe your behavior. Expert testimony from doctors or psychologists can explain how your mental state might have impacted your ability to understand and make decisions. The will itself can also be evidence. If it contains strange or unexpected provisions that don't match your previous wishes or estate plans, that might suggest you weren't fully capable when you signed it. It is important to remember that the court focuses on your mental state at the exact moment you sign the will. Evidence from before or after that time can be relevant but is not as strong. Medications like painkillers, sedatives, or anti-anxiety drugs can also impair judgment. Medical records or expert opinions can show whether these drugs affected your ability to understand what you were doing. In short, proving you lacked mental capacity involves showing that at the time of signing, you didn't understand the nature of making a will, the value of your property, or the people who would be affected. Medical records, witness accounts, expert opinions, and the content of the will itself all play a part in making this case. The goal is to demonstrate clearly and convincingly that you were not mentally capable when you signed the document.